Hey, ladies and gentlemen, this is Carmine Sabia for Explain America. And some people are saying that, the decision the other day in Colorado, it was really bad for Donald Trump. Let's take a look at it. But before we get started, please make sure you like, comment, share, and subscribe. Those little things really help us out and they help our channel continue to grow. A legal expert on MSNBC, that tells you everything you need to know right there, doesn't it? A legal expert on MSNBC was saying that the decision the other day by the Colorado judge that left Trump on the ballot was actually a bad thing for the former president. His reasoning was that the judge set a precedent by saying she does believe he's guilty of insurrection. Though he wasn't on trial in her court for insurrection, she believes he's guilty of inciting an insurrection. And here's why he said that's a bad thing. Let's take a look.
Please walk us through kind of what could happen from here.
Yeah, so I do argue appeals for a living, and I lived part of the year in Colorado, so I'm very familiar with the Colorado Supreme Court. And, I think, Andrew, and you have got it exactly right. If I were to put the headline on Friday night as an appeals lawyer, it would be, this is the very worst decision Donald Trump could get from the trial court, because it's going to go on appeal to the Colorado Supreme Court, perhaps the U.S. Supreme Court, and there Trump is going to face extreme headwinds. And the reason for that is the factual there's two parts, as Andrew says. There's the factual finding that the judge said, which is Trump committed insurrection. And then there's a legal part that the 14th Amendment doesn't apply to the office of the presidency. And on appeals, Jen, the factual findings get massive deference by the appeals court. It's almost impossible to overturn a trial judge's factual finding. You can overturn the legal findings because that's basically a fresh look at the legal thing. And here this judge factually made devastating findings against Trump and then looked at this legal technicality, which was, well, the 14th Amendment doesn't apply to the office of the president, which is so weak, even the judge themselves admitted that would be preposterous. And the reason for that is that there are other parts of the Constitution that say that the president is an office holder of the United States, which is kind of obvious. And the text, and the part you didn't bold when you flashed the 14th Amendment, says it applies to, quote, any office, civil or military, under the United States, as long as you've taken an oath. And of course, the president does take an oath. And it would be an insane reading otherwise. It would mean Jefferson Davis or Robert E. Lee could have run for the presidency in 1868. That cannot possibly be the law. And I don't think that it will command a majority of the Colorado Supreme Court or certainly the United States Supreme Court.
So you've argued a lot of cases before the Supreme Court. Would you take this case?
Hell yeah.
Now, I and other legal experts tend to disagree with him. The fact that that was one Colorado judge's finding doesn't mean it's likely to be a finding by appellate courts and the United States Supreme Court. It also doesn't insert the word presidency into Section 3 of the 14th Amendment. The word presidency is not there, and it lists a bunch of offices. You got to think it left out presidency on purpose, that it wasn't just an oversight. It wasn't, oh, we forgot presidency. No, that would be the first thing you think of. They listed a bunch of offices. Presidency was not one of them. I want to know what you guys think about this, so please let me know in the comments. Also, please remember to like, share, and subscribe. It really helps us out. I'm Carmine Sabia. This is Explain America. We love you guys. God bless you. Take care, everybody.